the Supreme Court, Republic of the Philippines, presenting the case number 214444 of November 17, 2020. People of the Philippines Pagpapanggap versus Lito Panya y Anandan, accused appellant.
The standard of legal insanity, which is complete deprivation of intelligence, is a concept born out of the narrow view that rejects the psychodynamic nature of human psychology. It fails to acknowledge that mental illnesses exist in a spectrum, and its all-or-nothing notion of mental illnesses reflects a detachment from established and contemporary concept of mental health. Persons who suffer from mental illnesses are no longer viewed as a wild beast who are absolutely devoid of mental faculties. Tests have been recalibrated and reformulated to better deal with the peculiarity and contours of insanity. Defense cases tests whose merits are now recognized by the court. This court resolves an appeal from the decision of the Court of Appeals affirming Lito Peña's conviction from the crime of murder. Upon arraignment, Peña pleaded not guilty to the charge. Trial on the merit ensued.
The prosecution presented the following witnesses: the victim's mother, Telma Makatangay, Aldwin Andal, PO3 Andres Mancia, and Municipal Health Officer Dr. Emilita Abacan. Based on the collective testimony of its witnesses, the prosecution alleged that on March 20, 2005, Andal left his house at around 7:30 a.m. to fetch Sherwin Makatangay from the latter's hut. When Andal arrived, he saw Panya hacking Makatangay with a 2-foot-long bolo. Makatangay was sleeping on the catre while he was being hacked. Afraid of what he had just witnessed, Andal immediately ran away and reported the incidents to the authorities. PO3 Mancia and PO1 Ranilo Balita were dispatched from Rosario Police Station to proceed to the crime scene. 8 when they arrived, they saw numerous bystanders in the area. They searched the place and saw Makatangay's lifeless body while they were conducting their on-site investigation. PO3 Mancia and PO1 Balita found Panya in a grassy lot 20 to 30 meters away from the crime scene. Panya was lying on the ground with a bolo in his hand. When Panya saw the police officers, he attempted to run but he was immediately apprehended. He was then brought to the police station. The post-mortem examination conducted by Dr. Abacan revealed that Makatangay sustained 4 inches wound on his head and neck, which caused his death. After the prosecution rested its case, the defense presented Panya and his mother Soledad Panya as witnesses. Panya interposed the defense insanity. Panya claimed that he had been mentally ill since 2003, which caused him to do things he was unaware of, suffer sleepless nights, and even attempt to commit suicide twice. In one instance, he jumped from the bridge but did not suffer any injuries. He further claimed that he was mentally ill in November 2004 and January 2005. He claimed that he absolutely had no recollection of what transpired on the day of the alleged incident and that he only regained his mental faculties after his apprehension and incarceration. The quack doctor, whom he had previously consulted, told him that his mental illness was brought about by depression. Soledad corroborated their son's testimony. She testified that her son was having health problems before the alleged incident and was quiet and uneasy most of the time. Soledad knew that her son was not in his right mind because he would answer differently whenever she would talk to him. Due to financial constraints, they were unable to seek professional medical intervention. One day of the alleged incident, Soledad observed that her son had a blank stare on his face. Moreover, Soledad maintained that his son and the victim who were close cousins, did not have any misunderstandings. When she visited her son in jail, he allegedly still unaware of what happened and did not recognize anyone.
In its decision, the Regional Trial Court found Panya guilty. The dispositive portion of its decision reads: for failure to establish by convincing evidence his alleged insanity at the time that Acos killed Sherwin Makatangay, the court renders its judgment of conviction and hereby sentence Acos Lito Panya Y. Inandan to suffer the penalty of reclusion perpetual. Furthermore, the Acos Lito Panya Y. Inandan is directed to pay the heirs of Sherwin Makatangay Y. Lara the amount of 50,000 as death indemnity.
The Regional Trial Court found the evidence presented by the defense insufficient to establish Panya's claim of insanity. The Regional Trial Court did not consider Panya and his mother as competent witnesses to testify on Panya's state of mind. Assuming their testimonies were given weight, it held that there was no proof that Panya was completely deprived of intelligence when the crime was committed. Panya appealed the decision of the Regional Trial Court. In his appellant's brief, Panya argued that expert testimony is not indispensable to prove his insanity, as this may establish by the testimony of one who is intimately acquainted with him. Panya believes that his mother is the best witness to testify on his mental condition, having observed his day-to-day behavior. Further, Panya argued that he had no ill motive toward the victim and there was no misunderstanding between them. Moreover, the totality of circumstances suggests that he was unaware of what he had done. First, he killed the victim in broad daylight. Second, he was found around 25 to 30 meters away from the crime scene after the incident. And lastly, he has shown no remorse. On the other hand, the people of the Philippines, through the Office of the Solicitor General, argued in its brief that Panya's guilt has been proven beyond reasonable doubt. It stated that the act of killing a sleeping victim is considered treacherous. Thus, the trial court did not err in rendering a judgment of conviction. As regards Panya's defense of insanity, the Office of the Solicitor General argued that legal insanity requires that the accused must be deprived of reason and act without the least discernment. The Office of the Solicitor General believes that the evidence presented by the defense showed that Panya only exhibited unusual behavior.
The Court of Appeals affirmed Peña's conviction in its March 13, 2014 decision. Thus, wherefore, the instant appeal in dismiss and the decision date January 24, 2012 of Regional Trial Court of Rosario, Batangas, Branch 87 in criminal case number RO5065 in affirm in toto. The appeal court agreed with the Regional Trial Court that Peña and his mother were not competent witnesses to testify on Peña's alleged insanity. Moreover, it found no clear evidence that would establish Peña's insanity immediately before or at the time he killed the victim. It held that the manifestation of Peña's alleged mental illness are insufficient to prove legal insanity, which requires complete deprivation of intelligence. In affirming the finding of guilt, the Court of Appeals found that the prosecution proved all the elements of murder. It held that the number of stab wounds sustained by the victim indicated Peña's intent to kill. The killing was also attended with a treachery as it was done while the victim was sleeping. Peña filed his notice of appeal, which was given due course by the Court of Appeals. The records were then elevated to this court. In resolution, this court noted the records forwarded by the Court of Appeals and required the parties to submit their respective supplement briefs. both parties manifested that they would no longer file their supplement briefs. The issue for this court's resolution is whether or not accused appellant Lito Peña Inandan can claim exemption from criminal liability based on the defense of insanity.
Considering the foregoing, under this test, the insanity defense may prosper if 1. The accused was unable to appreciate the nature and quality or the wrongfulness of his or her actions. 2. The inability occurred at the time of the commission of the crime. And 3. It must be as a result of mental illness or disorder. We now use a three-way test. First, insanity must be present at the time of the commission of the crime. Second, insanity, which is the primary cause of the criminal act, must be medically proven. And third, the effect of the insanity is the inability to appreciate the nature and quality or wrongfulness of the act. In this case, the defense failed to satisfy the test. Here, although the accused and his mother were presented as witnesses to prove accused appellant's insanity, the only witness who may be considered competent to testify on the accused's state of mind is the accused's mother, Soledad. An accused whose mental condition is under scrutiny cannot competently testify on their state of insanity. An insane person would naturally have no understanding or recollection of their actions and behavioral patterns. They would have to rely on hearsay evidence to prove their claims as to what actually happened. During cross-examination, accused appellant testified on matters that were only related to him by others.
Bakit ka kumonsulta sa isang albularyo? Ano ba ang nararamdaman mo nung panahon na yun?
Laging wala ako sa aking sarili.
Paano mo nalaman na nawawala ka na sa iyong pag-iisip?
Hindi ko alam sa mga oras na yun, pero sabi sa mga tao, wala ako sa katinoan.
At sinabi ng mga taong ito na nawawala ka sa iyong pag-iisip nung panahon na yon, na nakakaranas ka ng depresyon. Tama ba?
Opo ma'am, sinasabi nila sa akin kapag nasa katinoan ako.
At ano naman ang partikular na sinasabi sa'yo ng mga tao noong mga panahon na bumabalik ka na sa iyong katinoan?
Sinasabi sa akin ng iba na marami akong ginagawang kakaiba na hindi ko naman alam.
Pwede ka ba magbigay ng ilang halimbawa ng mga sinasabi sa'yo ng taong nakapaligid sa'yo?
Minsan sinabi nila sa akin na sinubukan magpakamatay sa pamamagitan ng pagdidikte nang hindi ko naman alam.
Soledad may be considered as a competent witness as she has personal knowledge of her son's behavior and conduct. In her testimony, she described the recurring manic episodes of her son in the past.
Bilang isang ina, paano mo mailalarawan ng iyong anak?
Mabuti po siyang tao, ma'am.
Mailalarawan mo ba ang kondisyon ni Lito Panya noong March 20, 2005?
Hirap po siyang makatulog, ma'am.
Maliban sa hindi niya pagtulog, meron ka pa bang ibang napansin na problema sa kanyang kalusugan?
Lagi po siyang tahimik at walang kibo.
Ano pang masasabi mo sa kondisyon ng kalusugan ni Lito Panya?
Parang lagi po siyang nakatulala at balisa.
Kailan mo simulang napansin na may problema pala sa kondisyon ni Lito Panya?
Matagal-tagal na rin po siguro, ma'am.
Naalala mo ba kung anong taon?
Mga taong 2003 po siguro, ma'am.
Ano namang ginagawa mong aksyon sa tuwing magkakaproblema sa kondisyon ni Lito Panya?
Dinala po namin siya sa albularyo para ipatingin, ma'am.
At bakit mo naman naisipan na dalhin sa isang albularyo?
Kasi po, para po siyang nawawala sa katinoan.
However, that accused appellant was uneasy, quiet, and suffered from sleepless nights does not make him legally insane. If at all, this may only have been manifestation of unusual behavior or his alleged depression. The sole testimony of accused appellant's mother was insufficient to show that his actions were caused by mental illness. In sum, The defense failed to show clear convincing evidence that as a result of mental illness, accused appellant was unable to appreciate the nature and quality of the wrongfulness of his acts at the time of the commission of the crime. Due to the failure of the accused appellant to prove that he was legally insane at the time of the commission of the offense, his conviction stands. Wherefore, the appeal is dismissed. The assailed March 13, 2014 decision of the Court of Appeals number 05483 is affirmed with modification. Moreover, he is ordered to pay the heirs of Sherwin Makatangay the amounts of 100,000 as civil indemnity, 100,000 as exemplary damage, and 100,000 as moral damages. Accused appellant Lito Panya Iandan is found guilty beyond reasonable doubt of murder and is sentenced to suffer the penalty of reclusion perpetua.